All right, good afternoon, everyone. Welcome back to another monthly edition of the Mortgage Law Today web show. Today we're excited to have two guests who are going to help us with primarily servicing related topics, although we have some other topics that I think will be interesting to everybody as well. First of all, we've got Loretta and we've got Sandy Shatz. I'm going to let them introduce themselves again, but of course we also have our co-host Loretta Salzano and our
Tuesday.
Yes, and our sponsor Peter Idziak from Polonsky, Beidel and Green, who we're very grateful to have aboard as well, who will help us with asking some questions. Of course, right now we're in the middle of the servicing conference at MBA. I'm not there myself, but we think it's a timely topic to talk about servicing. And looking forward to today's discussion, which is nothing's planned. We're just, as usual, we're going to ask some questions and have some fun. So I want to get to know our guests a little bit. I'm going to start with Laura. And Laura, I know you're in-house. Your company is both originating and servicing. And I'm curious, sort of what your role is and maybe focusing a little bit more on the servicing side, but also tell us what you're doing on the origination side.
Okay. Thanks, Brian. And thanks for asking me. And love that Loretta already brought up Fat Tuesday. It's big here in Texas, and I went to law school in New Orleans so many years ago. So we would be off today because nothing happens. They don't even deliver mail today in New Orleans. Wow. I'm sure everybody knows that, but it's kind of a weird, so happy Mardi Gras to everybody. And I have been in the industry for way too long, but back in a refi boom in 1993, I joined and then went off to law school, I think the following fall, and worked part-time with the mortgage banking law firm I was with. And now I was there for about 15 plus years and then went in-house with MetLife and kind of have moved through several different in-house mortgage banking legal groups and compliance. And over the years, I managed most of the risk areas or all of the risk areas. So now I oversee legal, compliance, quality control, quality assurance, vendor management, all kinds of things. And currently in this role, we use a subservicer. In the past, I've been in some roles where I oversee the kind of legal and compliance side for the servicing, where we done the servicing in-house. So mostly I've worked with subservicers, but in some roles I help on the legal and compliance side.
What are some of the roles that you have that you never learned about in law school?
Most of them, right?
Yeah.
I don't shepherdize cases, but gosh, I'm so glad we learned that.
Right.
No, it's funny. Actually, I worked. So my father and Marsha Williams were in law school together. I don't know how many people remember Marsha, but she was a giant. Is a giant in our in our legal community here in the industry. And when I moved to Dallas after I graduated from College of the Holy Cross in Worcester, Massachusetts, and from Texas though, so it was too cold. I'm coming back to Texas, and I ended up calling Marsha and saying, can you help me find a job? So I fell into mortgage lending by working at Middleburg, Riddle and Gianna, not in the legal department, but I worked in their we did doc prep. So I worked for one of the lenders there in our doc prep area, and learned as much as I could. And when I came back after law school, Mike Riddle and Marsha hired me into the legal department in Dallas in the doc prep area, part of the law firm. And I wrote like this beautiful 5-page memo for my first memo for one of the clients, and Marsha pulled me aside, just like, oh no, You got to get this down to no or yes in the first sentence, preferably yes, figuring out how to. And I have to say, best piece of advice I probably have received in my, that's not what you hear in law school, unfortunately. And then you come out and you're like, I just spent so much time and effort and crafted this wonderful memo, and it's like, throw it out, start over and get it down to a page and get the answer up in the first paragraph. And truly that has been such a gift for my career to figure out how to speak to executives, right? I've been on an executive team for a long time now and report into the board. And it's, give them the pertinent information with relevant facts. Don't elaborate too much unless you're asked questions. And then if you don't know the answer, say, I don't know right now, but I will research and get back to you quickly, and make sure you follow up on all that. And so that's really, I think, I didn't learn any of that in law school. I loved my experience at Loyola, I really did. But they don't teach you, I felt like I didn't learn some of the hard street facts that you need when you're on the job. But I do think Marcia helped so much, and Mike Riddle and Ira Middleberg in my early, like, how to work with executives and understand the risks, tell them how to, if we head down this path, we could do it, but let's put some guardrails up, and how to stay within the guardrails. And maybe, as another one of our fabulous giants in our industry used to say, are you going 65 in the 55, or are you going 55 in the 55, and how to get maybe closer to, from a risk perspective. So that's very long-winded, Brian. I'm sorry.
Yeah, no, you're right on the mark, and I really enjoy that. I want to put a pin in that conversation for when we come back to. I think Peter's got some great questions about artificial intelligence, and I want to talk about that in relation to the practice of law in mortgage making. But I have a story that when I was in house, I used to I had an associate counsel at one point, and I used to tell her that you don't have to do the A+ job, but you need to know what the A+ job looks like.
Right.
Right. We just need you to do the B+ maybe job on this, because we don't have time to monkey around. But you need to know what the A+ looks like. And I think that's really important. So you can make the judgment to say, and that's where having the mentors like you were talking about, I think, is really important. And maybe what might be lost in AI in junior associate world these days. And so now I'm going to segue over to Sandy. Sandy is recently of McGlinchey, but I actually don't know sort of what his current situation is, and would love to hear that. And I'd also like to hear how he became sort of the MBA's legal ethics rabbi, guru, whatever you want to call it, which is wonderful, because the guy that they used to have, I thought, was pretty dull. But Sandy's wonderful. And so anyway, take it away, Sandy.
Good afternoon, and Brian and Loretta, thank you for bringing me in. Peter, nice to see you, and Laura, nice to join you on the platform. Let me go back and kind of echo Laura's history. I also have a college degree and went to law school and started working in a litigation firm, and my focus was primarily on real estate stuff. And when I was in law school, I never heard of being a mortgage lawyer, didn't know what it was, and now I am one. And it happened when I went to a small financial services firm that did primarily litigated default servicing. And my biggest client was Countrywide, who brought me in-house. And as a litigator for the first 10 years, I could draft the most beautiful interrogatories and do the greatest motions. And I could do all sorts of wonderful things. And like Laura's great 5-page memo, I learned when I went in-house that nobody cared. And when I tell you nobody cared, I mean it with the greatest of love and affection and the broadest scope possible. The question was, what is the problem? How can we solve it? And the real issues from in-house are 3 questions, essentially. Is this a one-off or systemic effort, systemic issue? If it's a one-off, don't bother me, solve the case. If it's a systemic issue, let's get help. 2, is this going to involve regulatory review or not? If not, make it go away. And if so, we need to get help. And 3, will this attract publicity? If not, just deal with it and stop bothering me. So that's when I learned really how to litigate for clients as opposed to for law firm partners who like noun, verb, noun, and doing lots of work and lots of billing, solve the problem with the emphasis. When I went into Countrywide and worked there, we all talked eventually about, and when I talk in the field, the Great Recession or the mortgage downturn. If you've been around long enough, and I'm not going to assume anybody here is old, but you've all done this. When people say to me, hey, remember when the mortgage market turned down? And I say, yeah, which time? And you get the deer in the headlights look.
Yeah.
If you go back to the 2007-8 Great Recession, okay, you can go back to the late 1980s, early 1990s with that downturn, or you can go back to the late 1970s, early 1980s downturn, and I've lived through those. And in that way, you saw servicing change and you saw originations change throughout, but the theory has always stayed relatively the same. If you want to solve the problem, obviously take care of your lender clients, but help the borrower, because in litigation land and servicing land, a win is not the judgment you put on the wall that you can't collect or enforce. A win is the borrower's fanny in their property paying their mortgage. And when you shift to litigation and mortgage servicing in that regard, it's been good. When I started at Countrywide, before I went to Countrywide, I was active in the American Bar Association, the Consumer Financial Services Committee, was exposed to it. When I got to Countrywide, Susan Kelsey would encourage me to go to the MBA event and take part in those events. And that's where I spent more time doing that. But with the Great Recession, I got bored and I began reading the mortgage regs. So I began speaking about the mortgage regs. I have no one else.
The order of that,
fun,
the
you're
order of
reading
that
them
is
just
funny
for
because
fun. Just for fun.
Yeah, I have no one else who's had a hobby of reading mortgage regulation. When the mortgage reg came out, the proposed rules and then the final rules that were just after the Dodd-Frank Act, I actually sat down and read them. I know I probably should have gotten divorced. My wife goes to sleep early, so I read them after she went to sleep, and I read all that stuff. That's kind of a follow-on. When I joined the legal practice in California, the Civil Discovery Act of 1987 was just coming about. So I read those rules, and there I am, a 4-month, 4-week, 4-day associate, talking to the managing partner about these new rules and comparing them. He said, why don't you do a presentation to the attorneys on that? I thought what he said is, why don't you slit your wrists and commit suicide? But I tried that, and it really went over well. And speaking about the mortgage rules before others have read them kind of helps get people thinking about the rules. And there's a difference between legislation and regulations. Regulations are generally, please forgive me, don't vomit, well thought out, whereas legislation, again, please forgive me, is just chaotic, and whatever you feel like throwing together, stick it up against the wall, whatever falls off, that's your new rules. I don't want to sound overly cynical. Okay, fine. So I began learning stories and began speaking about the attorney-client privilege. In litigation land and frankly in servicing land, it's not really well understood or used, and began talking about it and then pitched to the MBA these kind of topics. Eventually, Thomas Fahn retired. He was the chap doing the twice-a-year legal ethics issue, and Justin Wiseman said to me, hey, you proposed something 2 years ago on a presentation. Are you willing to talk about it? I said, sure, I can do a 1-hour proposal on that. And they said, well, in the MBA, we do 2-hour ethics presentation. And I said, fine, I'll do an hour. Get someone else to do an hour, we'll be fine. And they said, no, you have to speak for 2 hours. I said, no, they won. So I talk about legal ethics and I follow it. It's an interesting field, and it's one where if you understand the rules of the game, and the rules that apply to us, for example, are model rule 1.13, the organization as clients, and understand how that rule works, it will make your job easier and better for when you're trying to maintain the attorney-client privilege and or trying to get work done. A lot of what we do is not privileged and not protectable.
All right,
we can
Sandy,
make
we
it
are
so.
not, we are not trying to get CLE on this MLT. We're not gonna.
I was done there.
So let's not talk too much about the rules. We'll save that for your next presentation. I sorry to cut you off, but I have a question now that I'm still waiting for an answer, which is, what are you up to now?
So today I started at Wright, Finley and Zach, a law firm in Southern California who focuses in this area and does a lot of work in this area. They are members of the MBA, active in the California Mortgage Bankers. Robert Finley, who I've long admired and respected, when McGlinchey imploded, wrote to me and said, "Are you okay?" I wrote back and said, "Hey, can I talk to you for some advice?" And I laid out what my situation was. And he said, "Okay, these are good options. These are good options. Have you considered our firm?" I've just shown him where all the bodies are buried, but he was a friend and I wanted the advice, and he made a fair offer and I took it.
Awesome.
So,
Congratulations. That's great.
when I was in-house at Countrywide, we had the Peralta Mortgage Relief Act. It's the 2923.5. And I was in-house and frustrated because I didn't like any of the briefs and I wanted to hire a amicus writer to do a brief, but someone else hired Robert to do the briefs. I read his brief, I gave him a call and said, "I'm done, great job." And the court ruled the way he had written the brief. If you're following California servicing, AB 130 is out there. This is the legislation dealing allegedly with silent seconds, but dealing with all seconds. And the way it's written is all originated first are now seconds. He has written the brief or the case and is one of two firms working on challenging the statute. And I've been following along with that before I went to his firm. It's just a fascinating area and I like what he does. So it's a good match for me and I'm pleased.
Well, that's great. And I do want to come back to some of those state issues as well in servicing. But what I'd like to sort of kick off a broader discussion, and then I got to get my other co-hosts the opportunity to ask some questions here. But I want to ask, what are you making of all of the consolidation right now in servicing? We've seen Mr. Cooper get acquired by Rocket. We've seen UWM. We've seen just recently PennyMac acquired Cenlar. So, these are some big moves. What do you think is happening, and what are just your thoughts on that? Either one of our guests.
I'm not the expert on this, but I think that people want to keep their loans, and this is a great way to have your book of business and keep them. But that's my 2 cents.
I had 2 thoughts watching this. You asked it in the mortgage perspective, but this is how the economy has rolled. What you're seeing is people develop a system and it works and they're scaling it. So they buy other servicing portfolios to scale their own portfolio, getting economies of scale and cost savings. So that's industry consolidation. And as that happens, it opens up new venues for smaller players who can become niche, and then they will grow and the system cycles through as the big players hopefully make it. But over the course of time, the big players have inevitably crashed and burned or slowed down or split off, either because of management issues, antitrust issues, or it's not such economies of scale to manage all these businesses. It's just more opportunity. It's opportunity for in-house folks, out-house folks. It's just, this is the American business cycle.
Okay. Loretta or Peter, you want to jump in with something here?
Yeah, I think it's both things, right? You want to try to capture as much business as you can. If somebody's already there in your fold, that's great. And I think as things continue to get more and more complex, it just makes sense to bring as much as you can, more volume, if you have the same systems and compliance management to put into place. It's so challenging. We have another, proposed rule, which I know we're going to see, is that federal rule DOA. I'd love to hear what folks think about that. And as we put into place more technology, that too has costs and monitoring risks. So how do you capitalize on that with an appropriate ROI? It takes a lot of volume, a whole lot of volume.
Yeah, I definitely agree with that. And I think also everybody touched on it, but sort of just increasing the size of your funnel. And to the extent you can keep your consumers and customers in your ecosystem, whether that's through, getting them through realtor partnerships or like with the Redfin acquisition, just having them in your system seems to be the current thinking.
Yeah.
And as for the niche, we've seen clients that have purchased servicing or sold their servicing. And if it's someone who has unique products, those kind of, full scale transfers can be very challenging because they don't have the right look back or whatever it is that's happening with their adjustments, especially with variable rate loans, can be extremely challenging. So I don't think we're going to see consolidation in a way that puts all smaller servicers out of business, but there certainly needs to be a sensitivity to that.
Yeah, I've also noticed if you're watching the Olympics, you probably have seen that there's an official mortgage partner of the Olympics, and it's PennyMac, who doesn't normally deal with consumers, at least hasn't in the past. So they've got a pretty clear strategy to reach out and change their model to be more consumer friendly, consumer focused, and we'll have to see how that plays out. I think you also can couple some of the discussions that you're hearing in Washington about relaxing the Basel framework to make servicing not quite so capital intensive. Should bring some banks back into it, frankly. So we'll have to see how that all plays out too. Loretta, I think I have you down for talking about
Yeah, absolutely. And Laura and I were chatting about this before the program when I reached out to invite her because, as someone who's counseling clients that are farming out their servicing and working with subservicers, it's a challenge because you're still on the hook as the owner of the servicing rights, but gratefully you have in the trenches servicing experience, but not all mortgage lenders and servicers have that same experience to bring to the table. So could you talk a little bit about your obligations as a master servicer and how you manage that when you hold the servicing rights but are relying upon someone to do the work in the weeds? So I know you deal with that all day, every day.
Yeah, thanks, Loretta. It is funny because it's, you have to remember that you are the master servicer and you own that, and explaining that sometimes to the business side is challenging because one's natural thought is, well, somebody else was responsible for managing that book for us. So it's been it's an interesting part of my day, my week, because wherever I've been, for the most part, it has been a master servicer, subservicer relationship with, like you said, a sprinkling of the servicing has been done in-house at a couple places where I've overseen the compliance and the legal aspect. But it's remembering the vendor management, keeping that compliance management plan around it, and checking in and overseeing and really making that partnership with your subservicer, that because it's very important. It's an integral piece to what I do, or what someone in my seat does as a day in, day out. I think it's getting with your group that works for your company that's overseeing the subservicer, making sure you're tied in closely with that group, as well as then making yourself available and putting time into some sort of regular cadence of meetings with your subservicer, right? And ensuring that you got good controls around all of that testing, that you're looped into seeing results of that testing. And then I'm also, I think someone in sitting over legal and compliance and probably exam management ties in as well, because you need so much of the data from the subservicing group. So it's keeping that relationship as a good working relationship, but also remembering all the tenets of good vendor management and keeping your compliance management plan in place and ensuring that you're kind of checking on policies and procedures, or if let's say you see something about junk fees coming out, and if it's reaching out and saying what kind of fees are being charged there, because we've learned over the years that even though somebody else is managing all that for us, as you stated, Loretta, we're responsible. So I need a person in my position needs to know what fees are being charged. Were they in the original promissory note? Are they? If they're not, how are we justifying those, and working again with that partner to ensure that there's some really good interaction, really good conversation, and that things are not being done in a vacuum way over here. So it's a constant reminder, that a remembrance that I need to loop in not only the internal group someone in my role needs to loop in the internal group that's managing it, but working with your external vendor partner and keeping all of those wheels greased with good information and good relationship management.
Yeah.
I think it's really hard to figure out like how deep you have to go. If everything's running smoothly and you haven't had customer complaints or nothing seems to be going sideways, sometimes it's hard to get leadership to invest in what you might think is an appropriate amount of monitoring. And to me, that's really the challenge oftentimes, is managing resources, because you're relying on their expertise to do it, but at the same time, how much tire kicking do you have to do as you move through it?
I think a good good indicator is to get a good quality control program going, so you're seeing those results. Also ensuring that you're seeing the customer complaints coming back over from that side,
Right.
and really using that as kind of a canary in a coal mine,
Of course.
aspect, right? And then ensuring that you're seeing exam results, and some of that asking, right? Like you're saying it immediately, but one has to remember to ask for results too, right? And say, okay, so yeah.
So I maybe let me throw it over to Sandy a little bit, rather than asking Laura this question, because you have one subservicing relationship, I'm assuming. Sandy, I would assume that you've been involved with subservicing negotiations, and that one of the sort of the important, maybe contentious provisions that might get negotiated are indemnifications and representations and warranties, and maybe you could speak a little bit to that.
No, that's not something I've spent a lot of time
Okay.
doing. Sorry.
Well, let me just say that those are important provisions to consider in furtherance of the issues that Laura was discussing, and leave it at that. That you definitely.
It's hard to get that, I think.
Yeah, you got to be worried about limitations on liability. I mean, your liability is not going to be limited, but if your subservicer's liability is limited, that could create an issue for you. If you're an originator and master servicer. All right, Peter.
Yeah, AI is the talk of the industry, every industry, it seems. You go to every conference and it dominates it. And so I guess, just two broad-based questions, like how are you educating yourself on AI development? And then from a compliance and risk management perspective, how are you engaging with the business or your clients whenever they come to you wanting to adopt new AI tools? And I guess either Laura or Sandy, whoever wants to go first.
Laura, do you want to start?
No, you're there. Go for it.
Okay, so in terms of learning and education, I'm spending, shockingly, lots of time reading, but not everything is helpful that you read, and a lot of the things that come out from MBA ads and other stuff. I am always leery of AI. It's fast, it's wonderful, and it on occasion hallucinates. So I'm seeing use of AI is good and great and needs even more compliance to double check the results that are coming out. And I'm guessing within 3 to 5 years, because of AI, I'll be out of a job and I'll do something different.
Well, I think that like the AI of the things that we think about for search results or researching things, is different than other ways to automate processes too, right?
Yeah, if you were looking for the AI and thinking, which is what I thought your question was, use of computers and artificial intelligence to help with servicing issues. And we're already processing things, most payments automatically, letters automatic, it's all generated. But the AI can be used in reviews for how are we doing and what's checking up, and then flag for people issues for further review, maintenance, or monitoring, or auditing is a good way of wording it. And we're not always doing that, and it's not always accurate, but we're seeing it taking more and more. And that's been helpful or potentially helpful, requiring a double check.
Where are we seeing it being used? What are some of the best use cases for AI?
What I'm seeing from client groups is reports on not just what they're doing, but what is the projection of what might be happening. So I will talk with a servicer. We're seeing trends in, okay, the usual number of loans have gone down, but looking at what's happening in this community, the numbers could be going up. We might be getting more customer calls.
Interesting. And Laura, how about you?
Again, my interactions have been a little more on the origination side and how it's being utilized on the I'm more aware of it on the origination side from the lines of business part of it, but I think probably it goes across origination and servicing to what tools can be used and honed reliably with lots of looking and checking and kind of going back after the fact to ensure that the right results are coming out, but utilizing it in ways in which we have been using it over time, you know, for in terms of like an automated underwriting system, or there's probably ways in the servicing side where maybe where people were having to look at documents. Now you could utilize some of the AI to pull information and make sure that that correct document is in the right file or with the right borrower. And so I'm sure that just like on the origination side, servicers are looking to inject in and ingest the AI tools, the proper AI tools that are working and to streamline and help end results for their different processes and improve the experience for both their master servicer clients and their consumer clients as well, so that maybe the process is more smooth and can be done more streamlined with fewer hiccups along the way. And it's such a high touch side of the business that any help that can be done there, I think, will be greatly received. But I do agree that with Loretta and with Sandy, there has to be so much oversight to ensure that the right results are happening, and then make adjustments if any adjustments are needed because the right result didn't quite come to fruition. If that makes sense.
Do you I'm always, I don't mean to put you all on the spot, but I'm always interested in servicing, when you're servicing a portfolio of borrowers where English isn't their first language, or they might have limited English proficiency. Do you know if there are opportunities out there using automation now or AI, or how that's being harnessed? It seems to me like a great opportunity, but of course, when we're looking at who we're dealing with, then it makes it ultra sensitive from a fair servicing perspective.
So I'm not as up to speed on the servicing side, but I do think that the AI piece is entering that LEP space and helping out for sure on the origination. So to my, if you just play that through, I'm sure it's being utilized more on the servicing side as well, because I think it's giving the opportunity for folks who want some help to, and again, assuming the lender's putting the right tools in place, but to ask for some help and receive it in particular languages. And then again, it's putting in the processes to check to make sure if someone asks for it in Spanish, it's coming out in Spanish and the correct Spanish pieces are falling in place. So, yep.
Yeah, it's definitely interesting. And, from my clients, what I'm seeing is a lot of what you talked about, Laura. It's the sort of automating data extraction and the initial analysis, basically stare and compare. But they're more hesitant to adopt anything that's sort of AI decisioning or generative AI. But I guess from the testing, perspective, it's interesting. There was some studies, a report that recently showed that, large language models know when they're being tested and may behave differently when they're being tested. So, what kind of
smart.
Yeah. What kind of unique, considerations are there whenever you're, testing your AI tools? If either of you have dealt with that.
I have not personally. So
yeah, for me, it seems like the biggest challenge is keeping up with the technological developments and the technical developments. So I'm talking to our CTO a lot more than I was in the past, trying to keep current with what's going on. Because for me, it feels like, okay, I just learned, chat. Oh, now Opus, with Claude is what everybody's using. Oh, no, now everyone's back at OpenAI.
My husband thinks Claude is my boyfriend. I'm like, I have Claude. He's like, who are you talking about Claude?
I thought
there are some people that actually do that. they have AI boyfriends and girlfriends.
Yeah.
Your comment was interesting that the AI knows when it's being audited, in that the journal reported this past week, oh good Lord, it's Tuesday, so last week, that AI on occasion is being malicious and now is getting smart enough to start being snarky and targeting its users. And that's causing concern as well, at the quote losing control of AI or what AI is doing. And that's also a worry and danger in general. And I don't know how it's impacting the mortgage market.
Well, let's talk a little bit about maybe litigation that you're seeing. You mentioned the state foreclosure issue in California. It's a foreclosure statute, isn't it? Maybe help me out. What's going on in California there, Sandy? And we've seen stuff in New York and some other states. What is going on with that?
I think if you're looking for a model or an organizational way of doing it, legislators are trying to do their best to slow down or prevent foreclosures, especially from people who either were surprised that they had a subordinate mortgage, or as a way of keeping the housing market, quote, stable so their citizen voters don't have to move so frequently. And I wouldn't want to call it as a roadblock, but these are improvements to the foreclosure process to make sure the borrowers are treated fairly. In California, the lender under AB 130 is supposed to certify a whole bunch of things as being true. And if they can't, they have to then disclose certain things as didn't comply with and didn't do. For example, sending monthly statements the entire time the loan was being serviced, something that's not required. And if you certify that we didn't send the monthly statements under AB 130, that's an unlawful practice. And the remedy for that could be a hold on the foreclosure or a prevention of the foreclosure or enforcement of the debt. There's a whole bunch of those categories within that. We're seeing similar things in New York with FHFA and other things, but the legislation is moving to make it more difficult to foreclose or bring more transparency to an already transparent process. So in addition to litigating the actual foreclosure, when a borrower defaults and doesn't make payments, we now have to litigate the hoops we're jumping through to do the foreclosure properly. And that effort is growing everywhere. I can't tell you why, except that there are more borrower voters than there are lender voters, as a guess. Same thing with the growth of rent control in cities. Oh boy, that was a conversation stopper. Sorry for the downer, guys.
Well, so Laura, maybe what other litigation are you seeing? As an in-house lawyer, are you supervising a litigation? I mean, I don't want to, pry on your.
I never see it. We're not luckily seeing much. So I'm trying to read Robert Finley's pieces of information that he sends out monthly and at different times, and stay on top of it, and make sure that we're discussing it at the executive level to try to stay ahead of it. But some of these are becoming overwhelming. I think, it's just the states seem to be stepping in. We are seeing some of it in different areas where the CFPB is not. So seeing, I think, Massachusetts is always, and again, this is more origination side, so sorry, I'm straying, but the Community Reinvestment Act for independent mortgage bankers, Massachusetts has had that for a while. New York and Illinois have finally just finalized their regulations towards that. So working on those pieces and then looking at the different cyber requirements for the different states, New York in particular, or then also Fannie and Freddie are getting involved in cyber requirements as well as notifications. And then I think Freddie just released some requirements towards artificial intelligence, and lenders need to be compliant with those by March of this year. So those kind of deadlines are the kinds of, and not necessarily litigation, but I'm worried about all of those in and amongst the different litigation trends that are out there. So it's a lot to keep up with as an in-house attorney.
There's been such a focus, at least there was under the prior administration, and now we see AGs filling voids where the feds have moved away on fees. And I know when I first started in-house back in the, early 90s, that was a huge thing, right? Like junk fees. But I feel like it's been pretty quiet, maybe because the industry settled down on fee issues related to servicing. Do you guys, is that something that you're hearing about or seeing? Whether it's just routine servicing or in connection with default servicing or loss met? I just haven't seen much clamoring. And Brian, I know you had a recent piece about credit, which is, another hot fee issue. So I'm just curious about that. I guess it's a radio silent thing again.
Most of the loan level litigation I'm seeing begins at the wrongful foreclosure level. A borrower wants to stay in their house and they'll just sue to stay in their house. That's not really what we're talking about. That's going to happen. There's a drop off in TCPA litigation, which is substituted for now at loan level with more FCRA, the Fair Credit Reporting Act litigation, and FCRA, and the FDCPA, the debt collection issues. We're also seeing at the loan level arise in the privacy issues, CCPA, for example, on those sides. The class level still is all new and novel theories, but the borrowers are doing what they can to stay in their house. Fees are not a huge, at the loan level litigation, fees are not a huge issue because lenders have, I don't want to say clean up their practice, but learn where the guardrails are.
Right.
So they're staying. And when the lenders master something, the borrower attorneys put their heads together and say, well, we haven't talked about this in a while. We get a whole new line of litigation. So, think back to the Nevada HOA lien issues. Those have largely been resolved and we're not seeing that anymore, but we're seeing something new.
Loretta, this was on your list of issues, but I'm going to go ahead and ask it because we only got a minute left. Sandy, you're in California. Laura, you're originally from Louisiana and Texas, and those are three of the states that probably have in recent times, if you add Florida, have had some of the worst issues with insurance because of the fires in California and the hurricanes in the other locations. What are you seeing now with that? A year or two ago, those were huge issues. You couldn't stop hearing about it. What are you hearing now?
I'm not hearing much, Brian. So I think people they're figuring out how to find providers for those different for their hazard and insurance. But I know California was definitely problematic, particularly with the recent fires, and trying to, for certain folks, it's going out and getting kind of Lloyd's of London to insure your house versus, USAA or, State Farm. So I think people are finding their ways to do it if they want to close on their house. It's just, maybe the noise level has, I agree with you. I haven't heard about it like we were hearing about it a year and a half ago.
They're probably chatting about it at the servicing conference right now.
Right?
California is huge from the legislative perspective. The legislature tried to do some things last year and couldn't get it through. And
Mhm.
it's on top of the priorities for this year. We're also seeing more homeowners insured through the FAIR plan, and coverages are lower and more expensive. So on a personal level, Farmers was my insurance company. They're now providing part of the insurance, and I'm a FAIR plan guy. So yeah, it's a problem, and I do not know what's going to happen in the horrific wildfire areas from last January. If the new building will have full-on insurance, and the cities aren't requiring it, but lenders are, and many people went bare in those fires because insurance was too expensive in California. So they're having their own problems.
Well, unfortunately, on that happy note, we are out of time for this month, but I want to thank our panelists, all of them, for their participation. Very much appreciated. And we'll look forward to seeing you again next month with a new topic and new people.
Thank you all
Thanks,
very much.
everyone.
Mardi Gras. Bye.
Thank you.
Happy
Thanks a
Mardi
lot.
Gras.
Happy Mardi Gras.
So we-